Young versus Iowa City Community School District. Mr. Geerdes. Oh, I didn't even see. Mr. Geerdes, we're going to have to, I didn't notice it, Justice. Oh, here she is. All right, you may come forward.
Thank you. May it please the court, Mr. Bracken. I have to start by saying that until now, I thought that depriving citizens of elections only happened in third world tin pot dictatorships, but unfortunately it happened in River City. I'd like to briefly talk about the statute, why it provides for an election, and then I would like to transition over into the constitutional side of things and explain constitutional violations which the deprivation of an election results in. I think the statutory analysis as the trial court found is relatively simple. The legislature has provided us with a referendum process. It has some fairly onerous requirements concerning number of signatures, time deadline, etc. It is conceded that we have met those requirements. The legislature also says that a petition is valid if no objection is timely filed. There have been no objections filed, either timely or untimely. Despite the fact that under both of those strands, the petition in this case is valid, an inferior political body, a local school board, somehow felt that it had the authority to declare invalid, to declare unauthorized what the legislature decided completely opposite.
Well, doesn't it depend on what a disposition is? I mean, isn't that the crux of the statutory argument? What amounts to a disposition?
First of all, I don't think you need to get there. As I recall, you wrote the Barrett decision.
I did.
And the Barrett decision says that if you want to challenge the validity of a statute, several things, of a referendum petition, several things come into play. First, the school board's local analysis is an extraordinarily limited one. It can determine from the face of the petition whether or not the statutory criteria has been met.
But the statute in Barrett didn't have the as authorized by law.
It had something similar but different words, okay? But if you were to look them up in the dictionary, they would be synonyms.
Let me just ask you, there's an argument that says that disposition means not demolition and repurposing. Okay. I mean, you're familiar with it, of course.
Yep.
That it really means an exchange. If you look at tax law, a disposition would not be demolition ordinarily, but that's tax law. I mean, that's context. If you look at in other contexts, if you look at the housing regulations, I think you'd find that disposition may well be demolition. But help me understand, in the context of this statute, why demolition and repurposing is a disposition.
First, we have to start with the black letter law, which says that statutes are interpreted by the use of common dictionary definitions. What happened in this case is that they cherry-picked definitions from law dictionaries.
I'm not sure there's any authoritative dictionary on disposition. I mean, there's multiple meanings, and it depends what dictionary you use. And you could come up with, I mean, there's dozens of different.
Let me answer it this way, and I think that if you look at what they plan to do with the building, there is a code section which authorizes school districts to dispose of buildings. School board says we want to demolish Hoover. So the question then becomes, how can the word disposition in one statute allow the school board to demolish a building, and at the same time, underneath a different statute, allow the school board to say that disposition doesn't have anything to do with demolition? They're totally separate things. You can't have your cake and eat it too. If you want to claim the benefit of one statute, you've got to recognize the authority and the similar language of another statute.
Here, as I hear this, I'm tending to agree with you and with Judge McPartland. But on the constitutional question, in a situation where you have an election law that's ambiguous, let's say, you may disagree, but let's say there was a position taken in good faith that by the school district, and there's a state law remedy for the situation which has been pursued and has been achieved, and now you want to say that the whole thing was a constitutional violation. Don't you have to have more than that in order to get a constitutional violation? What's your most comparable case to this one for your constitutional claim?
All of the cases cited in our brief are 1983 cases, okay? So let's start with this court's own decision in the Bowers case. And what this court said is that the constitutional rights of a referendum petitioner are equal to what the legislature gave him. And then let's go on to But
let's talk about a 1983 case that was pursued, that was successful, which you think is somehow comparable to this.
Okay, let's talk about the City of Berkeley rent control case. And that came down to being, at least in large part, a freedom of association case. And I think the freedom of association is an extraordinarily applicable constitutional right in this case, which has been violated. I say that because when you go back to the old NAACP civil rights cases that rise out of the 1950s, particularly the NAACP versus Button case, they say that there is a 1983 claim if the government's action has resulted in a violation of a person's freedom of association. And then it goes on to explain what the freedom of association is. And they say that it is more than just the ability to talk about a case, to talk about a problem. It is instead the right to utilize available legal means to peacefully accomplish available legal ends and political changes. Okay? In that case, the NAACP wanted to sue people who were...
Is the potential constitutional harm mitigated here, or maybe the claim is defeated? If I understand the timing of this, when Judge McPartland issues his ruling, it's coming up on the election itself. Is that right?
Correct.
And the judge made the decision here that it would not provide the relief that I believe your clients had requested, which was to kind of annul the votes that had already been cast, send out new ballots, and then either delay the election or have it on a different day. Is that right?
Yes. It was important to our political strategy to have our election on the same ballot as the bond election, because we believed that bond opponents who tended, in our view, to be fiscally conservative would also support our belief that it's foolish to destroy a fully functioning, fully utilized school.
But in this case, though, it was the judge who decided not to put this on the ballot based on the relief the judge ordered. That school district did not make that decision, right?
Right, but the school district certainly made the decision to deprive us of the election. because they stonewalled the election by refusing to forward the ballot to the county auditor as they were required to do. Freedom of association, as explained in Button and the Berkeley case, say that people have the right to join together and pursue desired political change.
Yeah, you know, that's right, but Button emphasizes this notion of chilling associational rights. In other words, the thrust of the case is, well, if the state engages in activity that discourages people from organizing, discourages people from pursuing legal avenues, chills, I think is the term that was used. That's the problem. How have you been chilled? I mean, I understand you didn't get your election because that was what the judge ruled, but does that amount to a chilling under freedom of association?
I think it most clearly does, because we have been denied the school board comes out and says this is an invalid petition. We take a vote, okay? That has not only deprived us of the 2017 election, it has contaminated the ability for us to get a clean election 6 or 7 weeks from now, especially considering the school board's ongoing campaign to say that the referendum isn't binding, we're going to do what we want to do, and by the way, we've accelerated our plans to show you what we're going to be doing to this site. All right, so we've got the school district that's come out and told the electors that this is a done deal and doesn't matter.
Here's what, I mean, I don't want to repeat myself, but at the risk of doing so, I mean, this is a question of federal law. We're interpreting 42 U.S.C. 1983 for the constitutional piece, assuming we agree with you on the interpretation of Iowa law. And the federal appeals courts have said, courts have long recognized that not every state election dispute implicates federal constitutional rights. Only in extraordinary circumstances will a challenge to a state or local election rise to the level of a constitutional deprivation. Now, this case, you were provided, you had an available remedy under state law. They had a legal opinion. It appeared to be acting in good faith. It was not a long-standing policy or a long-standing deprivation. It was not there wasn't a state law where the law itself denied constitutional rights. So why isn't this one of just those garden variety election disputes that the federal courts have told us doesn't implicate 1983?
What the federal courts say, and this is, I believe, fully consistent across the country, is that the wholesale refusal to hold an election is an automatic, bright-line rule of constitutional deprivation. And
you got a case for that proposition for me?
Absolutely. If you consider the this court cited it with approval in the Peterson case, and it's Duncan versus Poitras, which was a substantive due process case, and it said that there is a substantive due process violation if the entire electorate is disenfranchised.
It's the case about the judge that there was an entire election canceled over a candidate election.
Yeah, and of course the other one is the Bonus-Smithfield case, which came out of the Second Circuit, as I recalled, and it announces a bright line rule that substantive due process requires that you hold an election when state law requires you to do so. There's another thing that I would like to add in response to your question. The lady in the pink shirt is Heather Young. I will represent to you in my professional capacity that she is now a citizen of the state of Washington. She's not going to be able to vote. She spent hours and hours and days of her time doing something which the law allows her to do. The legislature gave her this option. If she could work her butt off and get enough signatures, there was going to be an election. That's something that she wanted. It's something that she's been permanently deprived of. That's why the First Amendment says, I don't remember the case on the top of my head, but any delay in First Amendment activity, First Amendment protected rights, is a violation. There's no blood, no foul rule when it comes to the First Amendment. I am 12 seconds over, so I will turn the court over. Thank you.
Mr. Geerdes, thank you as well. Mr. Bracken.
May it please the court. Mr. Geerdes. The issue here, I think the crux, I think, was the word that caught my ear. The crux here is, what does this statute say, and what does it mean, and how does it impact this particular set of circumstances? Without going through the statutory interpretation, without looking at the statute and see what it says and what it provides, you don't get to any other issues involved in this dispute. And in the specific statute we're talking about is 278.2. Chapter 278 is called Power of the Electors. It's been around since about the 1850s, near as I can tell, or 1860s, I believe. And it's been around about the powers of electors and what can they determine for how to run a school district. And that statute has been provided for some things that electors can do and some things they cannot do. That's just been part of the General Assembly's grant of authority to local electors. In about the 1950s, the legislature came up with Chapter 297 that talked about how school boards can run school districts, especially regarding their property and their schoolhouse sites. 278.2 provides the list of things that folks can vote upon. 278.1, but point 2 says submission of a proposition. And it says the board may, and in some circumstances it shall, submit to the county commissioner of elections any proposition authorized by law. And so there it is. There's the crux. In fact, I'll go one step farther and tell you it's actually a catch-22. Because if the board forwards a proposition or a public measure that's not authorized by law, then the board has violated the law. So there they stand, balanced on that. Do they or don't they? If they advance the proposition, they send it to the county commissioner of elections. Now the county commissioner of elections is going to hold an election not authorized by law.
So what is the case here that the demolition of this building is not authorized by law to be on a petition, to be on a referendum?
278.1, when it talks about the voters in the regular election, they can direct the sale, lease, or other disposition of any schoolhouse, school site, or other district property. Which I don't think, although we are talking about a whole school building in this particular case, I don't think we want to lose sight of other district property. So it's all property belonging to the school district is affected by this statute. So the voters can direct the sale, lease, or other disposition. That's what they're authorized to do by this chapter of the Iowa Code. Are they authorized to direct the demolition or destruction of school property? And our position is that they're not authorized by Chapter 278 to direct the demolition or disposition of school property. Now, the reason I raised that one point about all property is because, granted, yeah, we're talking about an entire school building here, but what if we're not? What if we're talking about a renovation? And every renovation includes some demolition.
If I understood your argument, it's that the school district has authority under 297.22 to direct the demolition of the property.
Actually, they don't need the authority under 297.22 to demolish. They've got all sorts of other authority in the code to demolish. And for example, I'll give elsewhere in 297.22, not in this particular subsection, but it also says that the board's actions are subject to Chapter 26. That's the chapter on public improvements. There's a section on Chapter 26 that talks about having a demolition crew on retainer. And the demolition crew, this applies now to school districts, counties, cities, all sorts of municipal organizations. So I don't need this particular language in this particular subsection of 279.22 to give the school board authority to demolish its own property. It's rife throughout the code, and just the inherent right to own property, which is in 274.1. In other words, there's all sorts of statutory authority for the school board to run the school district, including how to maintain its property, keep it up, 279.8, make rules for its schoolhouses and structures. So there's all sorts of authority throughout the code. This isn't the only place the school board had that authority. So I think we can set aside, I think it's a red herring to say, well, this is sort of a goose and gander argument that they raise. Well, if they took away the ability to vote on demolition from the electors, they took it away from the school board as well. Not so. The school board had all sorts of other authority in every school district to make these decisions, and as a practical matter, it has to.
Then what was the argument the school board was making that 297.22 gave the school board independent authority to demolish this building?
It gives it independent authority to sell, lease, or dispose of property anyway, and that actually goes to there's one of the issues,
which I assume by making that argument in the brief, you mean dispose equals demolition for the purposes of 297.22.
No, it's not. It's not necessary to do that. No, what our concern was is that there's independent authority of the school board because the ballot issue here, the public measure that was presented to the board is, let's be frank, and I think the petitioners have been frank with us too, it was something of a straw man. That is, shall the school district demolish the building? And what they were sincerely hoping for was that the vote would be no. And therefore, the argument would be now the school board cannot. And our authority is, well, wait, whatever the authority the school board has is under 297.22 is independent of whatever the voters may do under their power under Chapter 278. So we were just trying to unhook the authority the school boards have. In fact, the legislature made it easy for the court when it had 297.25 that said you have to interpret, the court has to interpret these things as separate and independent of one another, which sort of gets us down sort of at a governance level. What we're talking about is that's why I referenced the history here. The electors have had certain powers granted to them by the legislature for a long time, literally 19th century law. And more recently, the code has been amended over and over and over again to give public school boards more and more authority to run their school districts. And frankly, it's a part of the modernization of how school districts are operating now. They're now treated as municipal corporations. The idea of town hall type government over a school district township from the 1800s is really not an effective way to run your school districts. And so the legislature has authorized school boards with more and more authority to make these decisions. School boards, by the way, are still subject to popular vote and election. The school board members stand for election, and frankly, that's the representative government that is protected by the Constitution. I might point out, to get to the constitutional argument here, the Bowers case out of Polk County.
Can I ask you one more question
Certainly.
about this statutory question? And maybe I missed it in your brief, and if it's in there, that's fine. Are there citations to other sources of authority for a school board to dispose of property by demolition?
Yes. And in fact, Judge McPartland recognized some of those too. Now what they are they specific about disposal or demolition? No. But they are the general powers and authorities that are provided to school boards.
And what would be the policy reason here to make some sort of distinction between a sale, a lease, or a disposition and carve out demolition? It seems like there's some sort of legislative intent that the electors be allowed to weigh in when it deals with a major real estate type transaction. Right. And it seems like demolishing a school building is consistent with that.
Well, bear in mind, it's talking about school property, okay? So it's whether it's the entire building or just the wing that they want to improve the science lab. It's the same.
Is it even limited to real property?
No, it's all property. In fact, you want to go really heady about this, intangible property. So destroying data. could be subject to this same statute, if you really want to go way out there. But I think the easy answer to your question is it's not carved out at all. Demolition is something in addition to disposition. It's our thesis is disposition means a transfer of ownership or possession. And demolition doesn't do that. Now, the rubble that might be left from a demolition, there might be a disposition of that, but is merely tearing out a boiler and putting in a new boiler, tearing off a roof, putting on a new roof, tear out a science lab, put in a new science lab or a gymnasium or what have you. Are those, now those are all projects that might be subject to the public improvement statute in Chapter 26. There's a means and method that the legislature has dictated for us on how to manage those projects. But to carve out, I have to take exception because I think demolition is an expansion of 278.1 because it's more than just a transfer of ownership or possession. That's what this chapter of the code has always been about. Well, if you're going to transfer school district property, the electors have a right to do so. That's the 19th century law. And the 20th century law is that the school board was granted specifically some of those powers, and what Chapter 297, what it's really about is how, and what do you do with the money? 297.22 is all about posting notices and or holding public hearings about when you're transferring property, and what to do with the money you collect when you do transfer the property. It's not really an enabling statute on the school board's power authority. It's more of a statute controls of how it goes about controlling its property.
Why don't you address the Brent case, which basically stands for the proposition, well, you know what it stands for. Go ahead.
Yes. Actually, I think Berendt is not a bad, I think it's a good study for this particular case. Berendt said that the objections committee didn't have authority to make this a decision about whether a petition or public measure was lawfully sufficient. Interestingly then, the court went on to determine that part of the petition in that case wasn't lawful. It wasn't authorized by law. The one that caught my eye, part of the petition was we're going to get rid of the city manager and the chief of police. And this court said that was an unlawful petition. So I think to myself back to what public measures are authorized. So we might have one to get rid of the school superintendent and the football coach. Is that authorized by law under Chapter 278? And the answer, of course, is no. There's no authority for the people to fire the superintendent and the football coach. So you have to read Chapter 278. And you have to read it finely. Yes, I grant you that we're reading it finely. But the risk, of course, is if we allow a petition that's not authorized by law, then we've broken the law. Catch-22.
But don't you have to reconcile that with the language in 2777 saying, if the petition appears valid on its face, it shall be accepted for filing.
Yes.
And if it's accepted for filing, it's valid unless written objections are filed. And no written objections were filed. So how do you reconcile your position with that language?
Yeah, it's clear to us that the process for the objections committee and reviewing the petition are just for those mechanical features. Are there sufficient signatures? Are they residents of the district or municipality or what have you, district in a school case? And so it is just that mechanical kind of thing. In fact, the same process would apply to a person running for office. Had that person a nomination petition that had sufficient names, addresses, and signatures, that sort of thing. The idea about something being lawful or not doesn't change with the objections committee. It's still unlawful. If I ran for school board in Johnson County and I had enough signatures and I had enough the other mechanics, I filed the petition on time, it would be valid. But I don't live in Johnson County or the Iowa City Community School District. I am not eligible to be on their school board as a matter of law. It doesn't become lawful just because the objections committee says there's plenty of signatures here. We don't let 277 override the authority in 278.
Didn't we cross that bridge in Barron and say that really this appears valid is a very, very limited?
Yeah. Actually, I read Barron as saying the objections committee doesn't have that authority. And actually, it's the objections committee that doesn't even make the referral to the county commissioner of elections. The board does. Or in Barron, the city council. So it's actually a school board decision that has to has to make a determination about whether it's authorized by law, and the board in this case tried to make that determination.
So on the main issue of statutory interpretation, sale, lease, or other disposition of school property, your position is a sale is a transfer to somebody else. A lease is a transfer of possession to somebody else.
Yes.
So therefore, other disposition should
Yes.
be construed in the same category. It requires a transfer to somebody else.
Yes.
You demolish it, you still own it. Doesn't apply.
Right. Right. And I'll give you another, and so you might ask, well, what's a disposition if it's not a sale? Well, the statute also authorizes school boards to give property to cities and counties. And actually that happens. We've got old school buildings across the state that are obsolete and being closed down, and the town wants the building to put up apartments or something like that. They get it. Zero, it's not a sale, it's not a lease, they get it. But their transfer of ownership from the K-12 school district to the city of, I was down in New Virginia years ago and we did this, so that's another disposition that would be covered by the statute. And frankly, that would be something the electors could also weigh in on. We want you to dispose of this building by giving it to our local town. All right, but can they direct the demolition, especially in admittedly a straw man kind of vote? I've run out of time. We appreciate your patience. We ask that this court reverse the district court on its determination of these statutory issues, but affirm whatever decisions there were, that there were no violations of the petitioner's constitutional rights. Thank you.
Mr. Bracken, thank you as well. Mr. Geerdes, you may present your rebuttal.
Thank you. There's one important part of Barrett that we've not talked about, and that is the instructions that Justice Apple gave the government in that case. That instruction was that if you have an objection to the legal adequacy or a legal question, you need to let the district court decide the answer in the form of a deck action. How a local school board could ever take it upon itself to conclude that it had the authority to, by a vote, declare something to be unauthorized by law is beyond me. But that's exactly what they did here. I certainly think that an objective judiciary member is the one who needs to decide what statutes mean if there is a question about that. I have no explanation to give you for why they did not file a declaratory judgment action. Second thing I would like to go back to is some words of 278.1 which Mr. Bracken left out. What the legislature says is that the electors shall have the power to direct the sale, lease, or other disposition of any schoolhouse or school site. Now, certainly when you have a school site, let's just call it dirt, the only way you're going to get rid of dirt is by selling it, leasing it, giving it away, whatever. But the legislature wasn't concerned with just the dirt. For a very specific reason, the legislature said that the electors have the power to direct the disposition of a schoolhouse. Now, there's lots of ways you can get rid of a schoolhouse, including demolition.
Well, couldn't a school site be property that had been purchased for school use and then decided not to build?
I think the only way you can get rid of the underlying dirt, maybe property law experts have a different theory, but I think the only way you get rid of dirt is by selling it or leasing it or conveying it. You don't demolish dirt, but you do demolish schoolhouses. And what's going on here, obviously, is that the legislature wanted a process for the individual school communities to decide what we're going to do with our building. Tough choices need to be made, consolidation, whatever.
I see that as a possible interpretation. And I see that argument. But I guess the other argument is what the legislature was concerned about was sort of a waste of assets that by maybe a sweetheart deal with somebody or something like that, and giving the voters the opportunity to weigh in on that. And that's not at issue here with the demolition, is it?
Except, yes, I would submit respectfully that it is, because they want the voters to weigh in on what we're going to do with this property. You know, it is the voters' choice. I think in the overall picture, what the legislature, rightly or wrongly, is concerned about is who's going to decide. Are we going to let the school board tell us what is going to happen to our buildings? Or the electors, are the electors going to do so? And I think that's the thing that runs constantly through here. And the other thing, again, getting back to Barrett, what the legislature did not want, absolutely did not want, is they didn't want the local government body to be the one who is in charge of guarding the poll house door, okay? They wanted the judiciary to decide if there's going to be a legal question. They certainly didn't want the local government to stonewall an election by directly violating the statute and refusing to forward the admittedly valid, you know, think about this, the arrogance of refusing to forward an admittedly valid petition to the auditor. What's going on here, I have 5 seconds left, is that they didn't want an election. They had this facilities master plan that this election threatened to squelch. They weren't going to let that happen, and they didn't care what steps it took, including a blatant violation of the Iowa statute and a blatant violation of constitutional rights, to make sure that that election was going to be deprived to the referendum supporters. I'm out of time. Thank you.
Mr. Geerdes, thank you as well. Mr. Bracken, thank you again. The case of Young versus Iowa City Community School District is now submitted. And Mr. Geerdes, let me express our deepest sympathies for your loss. We are very, very sorry and appreciate the accommodations and the professionalism you exhibited, as well as you, Mr. Bracken.
Thank you. It's greatly appreciated.
Wish you the best. The bailiff may adjourn.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.